Thank you very much. And can everyone hear me? Yes, okay. It's a real pleasure to be here in this lovely setting. My name is Vikram Kumar. I'm a principal at Cornerstone Research in its London office. I'm primarily an antitrust economist and have been working a lot on class actions over the past few years, mostly on competition litigation related issues. I've also been doing work on privacy-related matters recently, so lots of interesting questions to deal with. With me here today is a panel that's here to talk about the role of economists and the role economics plays in class actions, and also the most kind of important bit about how these claims get administered as well. So I'll let the panel introduce themselves, starting with John.
Thank you very much, Vikram. Can you hear me? Yeah. So my name is Çeliktemur. It's spelled like Ken, but pronounced like John, just to let you know, in case you would like to have a conversation with me afterwards. So I'm a principal at the Brattle Group, London competition practice. And it's a privilege to be joining this panel on economic analysis as an economist. I've also worked on many class actions over the years, many in front of the UK CAT, some of them on the claimant side, such as the truck cartel follow-on litigation on behalf of RHA, others on the defendant side, such as the ongoing marine car carrier cartel case. So I hope to bring some my experience and expertise to this interesting topic, hopefully, today.
Hi, my name?
No.
Maybe Lara, you go next.
Sure.
Yeah, Lara, go ahead.
Oh, yeah, you can hear me. Hi, I'm Lara McDermott. I'm from Verita. We are an administrator, and I believe all my peers are here too from America. This is probably the biggest conference I've seen with all of my competitors. I'm actually from San Francisco, so it does appear I haven't left my house. I do live 5 miles north of the Golden Gate Bridge, and I think I can just go home at the moment because it's identical. I've been doing administration probably for 17 years here. I'm an EVP. I am not a quant. I'm an ex-banking auditor CPA, and my team effectively is downstream of the economists. So we evaluate all the plans of allocations. If anything, my team has the most active dialogue trying to interpret what these gentlemen write. And I think there are other colleagues in here. We did 2 of the big collective actions here in Europe for the last 4 or 5 years, and we really appreciate that active dialogue. So I highly recommend it. It works.
Thanks, Lara.
I'll try now, yeah. So my name is Martim Valente, or Martim Valente in English, if it's easier. I'm a senior counsel at PLMJ here in Lisbon. And before that, I worked in London and in Brussels. And since I've been back in Portugal for about 4 years, class actions and competition class actions in particular have been a big part of my diet. So it's a pleasure to be on this panel with you today.
Thanks very much, everyone. I'd like to just begin by making some observations based on kind of recent experience that I've had working in front of the CAT. One of the things that's kind of become really clear is that courts in the UK are not shy to deal with tricky, difficult statistical and econometric issues. There's a lot of appetite for it. And we'll talk a little bit about jurisdictional differences and how that plays out in different jurisdictions as well. But I think that, there's a clear recognition, at least in UK courts, that simplistic, very simplistic approaches to calculating damages and calculating harm to consumers will not always fly. So we hope to talk about those issues a little bit more. But I want to first start off with John. How do you think the role? What role do economists play in class actions, and how has it evolved based on your experience?
Sure. Thank you. Apologies. I'm going to resort to some slides to carry across some of my points, and I thought it would also be apt as an economist to bring some figures to this presentation. But as Vikram said, I'm going to talk about two things. One, I'm going to talk about briefly the role of an economist, especially in the UK class actions regime, and draw from some experiences. And then I'm going to talk about some recent trends in the UK class actions. So on the first topic of the role of economists, it's fair to say that the economist's role in at least the UK class actions varies depending on the phase of the claim. And I'll talk you through three different phases. First phase is I'd call the pre-certification phase. This is where the case is being developed, and there's the certification application being prepared and then submitted, and then there's a hearing for that certification application in front of the CAT. In this early phase, it depends on whether you're considering the claimant side or the defendant side, and the role of the economist varies slightly. So the claimant side expert economists will focus on questions such as the conduct and the theories of harm resulting from the conduct, trying to establish it, and then designing a methodology to estimate damages resulting from the conduct, and any data required to implement that methodology, along with a discussion of availability of sources. On the other hand, the defendant side expert will focus on a more responsive position, and it's also in the arising from the nature of having that staggered, taking turns in the early stage. Defendant's economists will rebut any of the points that the claimant's expert may have made, and then they may bring out additional points that are perhaps relevant for damages analysis, such as downstream pass-on or loss mitigation. These points would be brought out. Assuming that the class is successfully certified and the case progresses, and the second phase, which I call post-certification, there are a few different interesting points that the economists get involved. Firstly, disclosure. The defendant's expert would potentially support their clients in fulfilling their obligations related to disclosure. An innovation that we're seeing in the UK is a process called expert-led discovery, expert-led disclosure. The idea is the claimant side expert has their needs for implementing the methodology, and in coordination with defendant side experts tries to shape the disclosure. This is a neat idea in principle. However, in practice, there are some challenges, practical challenges to this we're seeing. Most notably, for example, even if the claimant side expert necessarily needs a certain type of data, it's not going to guarantee it's being disclosed, because there might be proportionality criterion that are not satisfied, and defendant side might argue it's disproportionately burdensome to disclose some of that requisite data. Once disclosure takes place, then analyses are carried out and exchange of reports take place. This could be simultaneous or sequential, and depending on subsequent submissions of reports will typically focus on critiques of previous submissions made by the other parties. And moving on, if the case further successfully carries on to the trial phase, then still the expert's role, or the economist's role broadly, doesn't end. There's firstly the exchange of opinions and testifying in front of the court. And one typical method that this exchange of opinions take place in the UK is hot tubbing. So hot tub is, the idea of hot tub is where you bring all the experts together from both claimant and defendant side, and the tribunal leads by themes, asking propositions or questions with the hope that the experts will engage in a debate in motivating and defending their opinions. Beyond hot tubbing and beyond the trial, there are also other areas where experts get involved, or economists broadly get involved. There's the settlement discussions and providing opinions to their clients on the claim value and damages estimates, or ultimately, should the case settle or have a judgment, the distribution phase may also require assistance from economists in implementing and assisting the administrators. So as you can see, economists are involved throughout the life cycle of a class action, from different areas, taking different roles, working with teams. If we can move on to the next slide, then I'll give you some trends on the UK class actions. As promised, as an economist, I thought I would be doing justice to my profession by putting up some figures. So let me give you a little bit of context on this. So this is part of research that we do at Brattle annually. We pull data. We love data as economists. We pull data from the CAT website on class actions filed. And we supplement that filing information with additional information on class size or funding from public resources like GCR articles or class representatives' own website. So we have this data set of class action activity in the UK. And I'm going to present to you some of the recent trends based on the most recent data that we've pulled. This is from from the previous month. So 2024 will appear for the first 3 quarters. Bear in mind it's going to be incomplete, therefore, and these are preliminary results, but I wanted to share in the interest of carrying out this conversation today. Now, what we're seeing on this slide is number of CPO applications filed in front of the CAT by years. And we break down in this slide the applications filed along 2 dimensions. One, by type of infringement, whether it was a anti-competitive agreement, like a cartel class action, or an abuse of dominance, like an excessive pricing case. The anti-competitive agreements are in navy blue blocks, and the abuse of dominance are in turquoise colors. And the second cut is by type of claim, whether it's a follow-on, following on from a precedent decision, authority decision, versus a standalone, whether it's there is no precedent decision that the claim is building upon. And standalone are indicated by solid blocks. The follow-on are indicated by diagonal stripes. So there are, when we look at this chart, 2 important trends emerge. One, the level of activity has been increasing. Notably, until 2021, there was about 2 cases on average per year, whereas following 2021, that number has increased considerably to about 7 to 8. You will see these are deduped numbers, so whenever there's a claim and multiple versions of similar claim against different defendants, just on a legal strategy, they're not counted twice to avoid duplication. So that's why you will see the numbers are around 7 to 8. And so overall activity has increased. And second trend is this increase has been coming from a rise on standalone abuse of dominance cases. That's the solid turquoise color since 2021. These are in particular in the tech industry against the big tech, like your Google cases against Google or Meta in relation to privacy and excessive data collection claims. If we can move to the next slide, please. Along with the rise in the activity, what we can also see is the total number of class members increasing, represented by these cases. Again, there's the navy blue representing class members as part of an anti-competitive agreement claim, and turquoise colors following on from or based on an abuse of dominance claim. The rise has been notably picking up after 2020 with the introduction of abuse of dominance claims, and it has reached to around 500 million class members in total. This amounts to about 8 class actions per UK citizen currently in the UK. And this rise has been driven mainly by the rise in the abuse of dominance cases that are really broad opt-out cases. And if we can move to the final slide, my final remark relates to the ecosystem. As we heard earlier today, there's a growing and diversifying ecosystem of funders in the UK. This is shown particularly by looking at this figure, where we see the number of distinct cases funded by litigation funders over the years, and each different color is a different litigation funder. And as you can see, it's quite a colorful figure, meaning there's a large number of diversified, distinct set of funders. And that has been on the rise with the increase following the 2020, with the rise of abuse of dominance claims as well. And one thing that's perhaps worth highlighting as my last remark is the presence of funders also introduced an interesting role for the economists, because funders, as we heard in the earlier session, it's quite expensive to fund a case, and it's quite risky. And funders would like perhaps sometimes an external set of eyes to sense check in early stages when the case is being developed. And we're seeing more and more the economists get involved as on a consulting basis, not on an expert role, but on a consulting basis to provide a red team exercise for the funders to see if the claim value and the case as being developed is supportive, and accordingly the funders may make their funding decisions. So that's kind of the role of economists in a nutshell.
Thanks very much, John. That's really helpful. One thing I want to do is try and compare that experience with how things have evolved in Portugal. So, Martim, I know it's still early stages, and it's being we're all here to talk about how things are evolving here. So, how are things evolving here in Portugal?
And why are we here?
Why
Portugal appeared. So, I think a lot of the answer to that question, a lot of that was already given this morning on the first panel, and some explanation on the Portuguese regime. It's opt-out. It's easy to bring a case. It's cheap to bring a case as compared possibly to other jurisdictions. I think from the economic, focusing this slightly on your role as economists and the way we see economists being involved and the importance of their work in these cases, I think a couple of things are particularly challenging here in Portugal if you're on the defense side, and I work primarily, entirely on the defense side, but and it's the tight deadlines. So you have, if you're a foreign-based defendant, you have up to 90 days after you've been served to present your defense. If you're a domestic defendant, you only have 60, and that's pretty intense, I think, under any metric. But I think that what makes this even more challenging for the entire defense, but in particular from the economic side of things and the way we've seen things play out in our experience, is the one-shot nature of that defense. So when we say one-shot, we mean you need to put in all of your defenses, legal, procedural, economic, factual. I mean, you don't have to go into the nth degree of detail, for example, on the economics, what you're going to say, but you have to have enough there that then in any subsequent expert report that you're able to submit later on in the proceedings, it's actually admissible. So you can only imagine, as an economist and the type of work that you do day to day, that having to work out how you're going to defend, and this is in the context of an antitrust case, but firstly you can identify the data that you need. Where is that data? How's it held? How much cleaning needs to be done? How are you going to work out the incentives? You're going to have to explain incentives depending on which side you are, but you're going to have to present a defense in that respect. Anything related to efficiencies that you may want to say, anything that you want to say with respect to passing on, either way in which you would evoke that. And obviously when it comes to damages, you don't have to put in a fully fledged damages defense, but you have to at least have a good grasp of everything that you will want to say in the future from the economic side of things. That can be challenging just because you might be looking at absolutely enormous volumes of data or very big volumes of data. And so 90 days, or in other situations 60 days, that's something which is particularly challenging here as a jurisdiction.
But on the plaintiff side, the experts, obviously, they know when they're going to bring the action, and typically when the complaint comes in, you get an expert report along with the complaint. Is that
so? What we've not necessarily. So we've seen situations where you have an initial expert report. So this is initially what we want to say, and what claimants have been saying is, here is the initial economic report, and then they make a disclosure request, and they say, and we will require all of this information to supplement, firstly because we want access to that information, to those documents, but ultimately also then to supplement what is going to be in the plaintiff's more developed economic expert report.
Right, and but when the first defense goes in, you don't have an expert report. You only have the.
You might have an initial one, which is relatively limited.
I
So
see.
it's not going to be something which is going to be hugely. It's going to be an outline, perhaps more than you would have in the defense itself. But it's going to be. It could be an expert report. It will certainly be always framed, I think, what we've seen so far as an initial report that requires subsequent disclosure and evidence.
Right. And what kind of economic evidence is the courts asking for?
So things have been moving slowly in Portugal.
Mm.
So we've had a lot of cases, and we heard today, this morning, we've had, I don't know exactly what the total number is, but I think a figure was mentioned of 60-odd cases last year or something of that type. In the competition space, certainly over 20 cases. We haven't actually reached a situation where there's been hearings or we've reached a first instance ruling. I think that what we've seen, though, in other cases, so in let's say in follow-on cases, which you would expect the approach would be broadly similar, and it's also the competition court that would be addressing those issues on competition cases, is that it's not sufficient just to reject and rebut and undermine what's being put up against you. We've seen the courts have been more exacting. They also require an alternative, a counterfactual, so analysis that we in the competition world we love very much, the counterfactual and how we're going to evidence that from a data perspective, alternative calculations, an alternative counterfactual, but also a theoretical framework. So not just these are the numbers, these are how we think the incentives are going to play out, this is how the efficiencies work, but actually something which is also more theoretical to give the court the option to, if they decide not to go down that route, to go down through a more theoretical framework, because as is the case in many jurisdictions, judges are different. The ability for judges to feel comfortable with economic data, we can't tell you empirically what it is so far in Portugal. We expect it will get better over time, but even then it will change. It will depend on the judge. The competition court here in Portugal is specialist in name, not by nature. So it's not like in the UK we have specialist economists and specialist lawyers who go and join the CAT. You have judges who are taken from the general pool of judges and then do a term at the competition court. So it's a completely different kettle of fish in terms of presenting your data in your expert report.
That's quite interesting, and it's kind of related to the point I was making earlier, which is that when you think about recent cases in the UK, at least, I think there have been 3 cases that have actually gone all the way to trial. There was a case called Brattle, after which there was Royal Mail, which is one of the trucks cases, and then there was the LCD panel case, all of which were follow-on damages cases. And what became clear, at least on the LCD case, was that there's this real desire from the judges to actually sink their teeth into the complexities of the analyses. There's a real desire to understand, what is, to the extent of saying, what exactly does a type 1 error mean? What exactly does a type 2 error mean? If I have to make a decision based on balance of probabilities, did this conduct actually create any harm? There's willingness to actually understand, what exactly is going on. There's real willingness to understand what the econometric model actually means. Or is there endogeneity in the model? So there are, judges at least seem to be fairly sophisticated, and on the LCD panel case in particular, you saw a clear difference between the approaches taken by the 2 parties. One party essentially, it was, like I said, it was a follow-on damages case. One party essentially said, okay, I'm going to look at the price trend before the cartel and then just forecast it, or essentially assume that the same trend would continue over time, and on that basis calculate damages. Whereas the other party, I think on the defense side, basically they said, no, such a simplistic approach is not going to work. You're going to take a more sophisticated approach. They use a regression model, controlling for a bunch of factors. And then the court was, it recognized that that's a more robust way of doing things, while recognizing that even when you implement a what you may call a sophisticated methodology, that still comes with limitations. You still have to apply the broad brush approach. You still need to recognize that it's not going to be a perfect solution. So I think it's taken a long time, but there's certainly recognition of the fact that you need to grapple with the complexities of the issue. Lara, you obviously come a little later in the process. So I think at least for me, it's been quite eye-opening coming here today, listening to what administrators actually do from a European perspective. I had no idea what exactly an administrator did. So all ears to hear about what.
We actually had a couple free sessions, and he was, honestly, what do you do? It was quite, I appreciate that. I think you have many different panels today where you're going to have claims administrators speak. So I'm trying to, so I put together kind of 3 topics to speak on, which is really how does and keep all of this administration functions and roles as it pertains to the economic plan, how the plan of allocation or the distribution plan. So everyone else can speak on other pieces of notice and pieces. But kind of the role of the administrator in coordination with the damage experts, kind of lessons learned, I might say, or additions here on liaising with the economists throughout the administration. Kind of I'll explain issues that often arise that maybe you guys could leverage or use, or hopefully. And then kind of thirdly is kind of comments, or I might say cultural differences I'm seeing between the US, the UK, Portugal, and the Netherlands. So I believe one of my peers said it earlier. I think in general for an administrator, we try to be neutral. In any given case, we might be hired by a defense counsel, plaintiff's counsel, the defendant, the court, a government agency, or even asked to opt in on some. So we are really trying to stay neutral at all times. I often tell people my job is not cocktail friendly. It's very hard to explain. And I said, whatever was in the newspapers 4 to 5 years ago, that's my day job. I'm about 4 to 5 years behind the news because that's how long it takes all of you to work through a matter, and then you're ready to engage an administrator. I kind of think we're fresh blood for you. We're new energy. Suddenly when you're ready for the administrator, you want us to help you design a beautiful website. You want us to, can I take all your legalese and actually try to put it in a layman's term? Can I make it, what do you call it? Use white space better, Sorry, the legal. I'm not a lawyer by training. I'm a CPA. Try to make it more interactive, because really what you're asking us to do is you might have this claimant base. Everyone comes into this thing with assumptions, and then suddenly the administration starts and everyone starts getting frustrated because someone's assumptions are probably not accurate, or someone's assumptions aren't reality happening, and then everyone wants to start pointing fingers of why is that happening. So I really believe the role of the administrator is to help keep everyone on the same page, communicate, try to get your claimant group or your claimant as informed as possible, and when information is not going as expected, start communicating early. I had other ones here I wanted to say. Counsel, what works against us is typically the age of the data and the age of the class. So, pretty much everything you guys are preparing your economic analysis on is almost 6 to 10 years old. By the time it gets to us and I'm trying to reach out to the claimants, or we're trying to get you to say, oh, you want to be a part of it or find your evidence, it's getting really difficult to get that evidence in. That's not working in your favor. So I agree that the current cases out here are taking longer. It's a kind of a disservice to the class. If we can keep moving them along, I think you get a better representation, or you get a better take rate, you get a better interaction with the class. You don't lose their interest. Also, I do believe you really should be, I don't think we're all so independently of each other. For example, when we worked on the big Steinhoff case, we've done 2 of the largest collective actions here out of the Netherlands. And I believe the Economist is in the room. It was complicated. It's, 40 pages, 30 pages long, and we tried to make it into formulas. So oftentimes we made samples, examples for the claimants just to make it more usable. Put those samples on a website. And then when challenges come up, we are going back to the damage experts asking what was the spirit of this. Your administrator should be, we all do what we call plans of allocation matrices, where we are testing every single cell. We're looking to see if a date was missed. I mean, you guys might have written it, and then it went through 25 versions and a lot of lawyers, and then it got handed to us. So maybe some of your words were removed, I'm sorry, or a table was accidentally left out. We're coming back to determine what was the intent of it, and then so that we actually have a complete administration for you. Sometimes we even have really complicated disputes or sophisticated investors that are challenging the assumptions. Hence, we will reach the counsel again and go right back to the damage experts again. So it is extremely important who you're choosing as your damage expert, and this liaison is very helpful. What else have we got? Spirit, POA matrix. Probably one other main concept to think of. How do I say, no disrespect? Sometimes what people think we can get as data is truly not available 5 or 6 years later, right? We're using data for an unintended purpose, right? It's imperfect data, and we have to make decisions or adjudicate a claim based upon that data, or come to it. For example, like in a securities case, it is so hard when we're given multiple, let's call them hold dates, and it's a mid-month or like a random day, like the 11th of a random month. Yeah, no one's got that date. So now you're gaming data information, trying to determine, did this person really have that hold at that particular time? Or, I've mentioned this in another conference last year, a typical problem or issue in these plans of allocations is everyone thinks these are purchases and sales or acquisitions. And well, what about everything that's not a purchase and acquisition, which is acquired by merger, or was a transfer in, or was a transfer out? It had no, did you really rely on the information? Or were you just moving assets for risk management purposes because for your various different custodians? All very critical. And then probably my third or final point here on kind of comments. I know the recent regulation, or I mean the recent case, the Boundary Affairs case that came out in the UK. Vikram asked me to look at it, so I was looking at the plan of allocation. I like the concept that there are 3 pots of money. I like the concept that you are taking care of what we call the squeaky wheel, those that actually kept all their documentation and wants to change. I want every dollar because I saved my documentation for the last 12 years, versus the other claim like, well, yeah, I think I rode the train. I think I did it. Okay, great. Yeah, I'll just sign and I'll take the whatever, the 25 or 30 pound scenario. That's also quite common in the US. We have a number of consumer matters. And then oftentimes it has like a spillover effect. So yes, you initially put a pot of monies for each subgroup. So based upon one claimant group has good documentation and can receive it, and then others are willing to take less money because they know they didn't keep all the information, but it keeps your take rate up. You're keeping a larger pool of your potential claimants to be involved. So I think that is a good solution, and is quite well used out for as well. Lastly, when I say to culture, I think I think someone also mentioned it as well. We're very paper-based in the U.S., only on disbursements or checks. I don't know, just darn. The older demographic of the U.S. really likes their checkbooks, I guess. The matters here, and I think we've done 3 large matters now here in continental Europe, 2 collective actions and a recent action in Austria, in the hundreds of thousands of payments. I am impressed, and I really love the culture. Everyone here is very much adapting digital payments, electronic payments. There is not a single physical, even contemplation of a check, or even a physical notice. Everything is electronic. All your deficiencies are electronic, all your payments, all your communication. So we could learn from you. I'm trying to encourage that behavior back there. I guess my message is, please keep the dialogue open. It's really healthy for your administration, and I think it will benefit you, it'll benefit your class, and everyone will look better in front of the judge and the courts if we are all working this closely together.
Thank you. one thing I want to come back to you, Martim, was around this question of seeing kind of similar cases appear in different jurisdictions. So I think we've been involved in a couple, but just want to see if you had any comments or thoughts on that.
Well, yeah, it's certainly one of the main features and drivers of what's been happening across Europe and certainly here in Portugal. I think from an economics standpoint, this is generally true, but focusing on the economic side of things, you can, because of the other features of the system here in Portugal that I mentioned, the tight deadlines and the one-shot nature of the jurisdiction. I think Rita mentioned this earlier today at the first panel. You might have Portugal overtaking other jurisdictions, even though the claim was brought 2, 3, 4 years later than in other situations. That can have. It's good sometimes to come second or third or fourth. I mean, from the economics perspective, our experience has been that and that means that you're not in a standing. You're not starting from a standing start. So you may have already addressed situations. Where is the data? What does it look like? How do we need to complete data? One of the things, though, which I think that is important to bear in mind is even if the cases look and feel as if they're probably similar, oftentimes, even across jurisdictions, they're going to be quite different. So the defendant might be the same, some of the conduct might be the same, but that's not the case that it's always going to be the same. So I think from an economic standpoint, one of the specificities of here in Portugal is that you obviously have these tight timelines, and you need to get things right from the outset. I think it creates, it means the economists play a really important role in working out exactly how all of the analysis that's taken place beforehand, how that would apply actually in the local market here, and the extent to which additional data is required. I think one area, again, which I think will bring some light into how different things can and cannot be, or may not be, will also be an area which I know that you guys have been working quite a lot on recently, which is disclosure. So to see exactly what types of economic evidence are accepted, required by the courts, accepted by the other side, accepted to be given by. So there is certainly some harmonization in terms of a claim being brought in different places. I think Portugal can actually be used as quite strategically by claimants. We know that we have these options that benefit us. Let's try and force them to have to put something on the record earlier than they would in other places where maybe the amounts are higher. But yes, so I think the existence of multi-jurisdictional claims is very relevant to the increase of cases here in Portugal.
Is there a concept of joint expert meetings, joint expert reports? Is that something that's at least allowed?
Not in the same way as you would find in the US or the UK.
Okay. And John, do you have any experience doing joint expert statements, expert reports?
Yes, indeed. That's in the later stages, especially, that's typically something requested by the tribunal. We're seeing more and more of. It's meant to, provide a consolidated summary of where the experts stand and shape how the tribunal should approach. But obviously, it could be a repetition, a lengthy repetition of what's already been disclosed. So making it effective and really helpful is as much an art as science of consolidating. But on the disclosure, I just wanted to make a couple points, if I may.
Please, yeah.
So, as I mentioned, disclosure doesn't take place until later in the UK experience. So at early stages, when you're building a case, then what do you do? That's a challenge, especially for the claimant side. So one thing is, firstly, the data that you will require, all you need to show is that there's available sources and potentially references to other publications or other investigations may indicate that data will be available from the defendants, but also similarly the existing studies or market investigations will be potentially helpful to support that early stages. This is particularly relevant in a standalone case. When it's follow-on for an abuse of dominance, you can simply rely on the decision you're building on, but on a standalone, you have to additionally establish dominance, and that could be quite tricky, but references to other jurisdictional decisions or from the same jurisdiction related but not specifically a precedent decision will be helpful to provide building the case for especially the standalone claims. And then once disclosure takes place, that's not the end of the Economist's challenges. There are a few glitches also to keep in mind. One is consolidating disclosure across a multi-party, for example, cartel setting has its challenges. And that's where ideally defendants experts would be coordinating with among the experts, and that's where joint expert meetings come into place, tying it, to consolidate the data across the parties so that it's kind of on a like-for-like basis. You don't have apples and oranges problems. And last thing is, even if you have disclosure, the case might be an indirect purchaser claim, and there might be non-parties to the litigation from whom data would be helpful if they had, but then they're not parties to the litigation, so there cannot be a disclosure expected. So these are potential practical challenges that economists have to work around with.
Yeah, and I think just to add to the practical challenges bit, which is, picking up on what you said, which is, a kind of defendant experts coordinating with each other. I think the main issue we find is that every defendant's data system is completely different. And so to coordinate across defendants, across, say, a joint defense group just becomes a big nightmare. There's this, pie in the sky hope that, there'll be a data pool where everyone will just dip in and out and just take whatever data they need, which I've seen tribunals recommend, but it's just not workable. And, the idea is just shelved.
Data record keeping practices differ.
It's just completely different.
Financial years differ.
Yeah.
You need to take all these into account, and devil is in the details when it comes to data work.
Very good. Anyone, any comments
good.
to add?
Thank
I think we have about 3 minutes left. I'm happy to open the floor to any questions people may have. I think there's one there at the back.
Excuse me.
That's what I was afraid of.
Yeah.
I know the sessions now titled Critical Role of the Economic Analysis, but I'm interested on Lara comments before about cases involving data, digital electronic data. So is it fair to say that data forensic sort of investigation, data investigation is also necessary in this class action case?
I'm sorry, are you saying data investigation? Or are you saying what we call known data? Sometimes the defendants or the subpoena, and we get all the data from the underlying defendant, and then we start the administration from that perspective.
Right, but because nowadays, most of the cases, we talk about digital platform, right? Like we discussed about TikTok before. So I'm wondering, is there any role other than economic analysis? Do you require like data forensic or sort of, computer scientists to work on that, preparing the data? I'm not to discredit about the role of economic analysis, but I'm just curious.
No offense taken. No.
I think most of us, or most of the large administrators in the room, we all have very strong data teams. So yes, we all have a lot of data analysts and data managers that will apply a set of rules and scrub that data as we set up for the administration.
So it's part of the administrator.
Especially when it's known data, and as the whole world is becoming more digital, and you got a combination. Everyone used to keep data. Now companies are. I'm sorry, you're past 7 years. That data is gone. So either ask for a legal hold early, please. So my data doesn't just drop off, and you've given me a 6-year time period, and I only have data for 4 years, and we're making assumptions for these other previous 2 years to try to come up with a logical method. I'd say in the consumer cases on the U.S. side, almost more than 60% are now coming in with a very large data set to begin with. So we're only supplementing that outreach, trying to find what we call NIDB, not in database, other claimants that can join in action if we believe that you truly are a human, not fraud, not a bot. That's a bigger problem. I think that's tomorrow's discussion for somebody else. But we are all using data very much so. And we're also using it to kind of validate you. So counsel or the damage experts may require me to do some sort of claim liability release or something, but I have enough data that I'm validating or I'm challenging or I'm pre-populating your claim for you. What we think it is really you're just signing because we think we have all the knowledge, but if you have more, now you have to give me evidence to prove more. Otherwise, sign the claim form and we'll pay accordingly. And then my other comment on payments for just Europe in general, I think because of the foundation and your SEPA. I'm in love with your SEPA payments. It's amazing. I'd like that in the US, please. That's wonderful.
Thank you, Lara.
I think we're out of time. Thanks everyone.
Thank you.